All right, good morning, everyone. Court will resume with the June 15th, 2022 docket. And we have Mr. Rogelio Garza and Mr. Daniel Lopez on CL 193350D, Benita Hernandez, Petra Martinez versus County of Hidalgo. All right, let's see, Mr. Lopez and Mr. Garza.
No audio
No audio.
for Mr. Lopez.
All right. Let's see. How about Mr. Garza? No audio either? Okay, there you go. Nothing? Okay.
Judge, I don't know if you can hear me, but I
Yes.
cannot hear anybody.
Can you hear me now? No?
He cannot hear you.
Okay. Wow. All right.
If
Mr. Lopez is connecting. No, Mr. Lopez is.
I see Mr. Lopez is also having trouble, but I still can't hear
Okay.
anybody. May I make an announcement?
Yes, go ahead.
We're going to submit an agreed order for
Okay.
a mediation to be held within 120 days. And we've agreed with mediator Daniel Hernandez, sorry. Lopez is, I don't want the
Okay.
defense attorney as my mediator, that's for sure.
Got it. That's
Okay.
it.
Thank you.
Got it.
Okay.
Thank
Good seeing
you.
you, Judge.
Thank you,
so
sir.
much.
That's it.
Okay,
And I'll
Mr.
prepare the order. I'll submit
Okay,
it.
good.
Okay,
Mr. Lopez
I'll call
needs to unmute.
Daniel and let him know.
All right, let him know, please.
Thank you.
I think I just got on.
Okay, good. Mr. Lopez.
Yeah, and I had spoken, Judge, I'm sorry about that. Not the most tech savvy guy. But we have spoken and
Yes.
he was going to make an announcement. I'm sure he did. And I will wait to talk to Rogelio, and I appreciate it.
Okay, he announced an agreement. That'll work. Thank you very
Okay.
much.
Okay, thanks.
sir. Thank you. Bye-bye. All right. Let's see who we're going to get next. We need to match the attorney with the client.
Mr. Benjamin Gutierrez.
Okay, that would be number
Number 5.
5. Okay. Oh, there it is. Default hearing, right?
Mhm.
Mr. Benjamin Gutierrez is connecting. It's against Juan Valerio. All right. Agreed judgment on this one, order for mediation within 100 days with 10. Okay. All right, Mr. Gutierrez is connecting. Anybody else we can match? There's Rafael de la Garza there. All right, Mr. Gutierrez. This is number 5. All right, you need to unmute Mr. Gutierrez.
Good morning.
There you are. Good morning. Good to see you, sir. You're here on a default hearing, right, sir?
Correct, Your Honor.
Okay, and I believe it's going to be CL 22-0031D, Citibank NA versus Juan Valerio. Court will note that Juan Valerio is not in the waiting room nor at the courthouse. So therefore, court will take judicial notice of the entire file, and you may proceed.
Thank you, Your Honor. May it please the court, Your Honor, we're asking for redress in the amount of $2,191.22 plus court costs and attorney's fees of $730.41. And within the file, the court will see that there's a business records affidavit from Sergio Guerrera. Therein, Mr. Guerrera attests to the account, the delinquency of the account, and the grounds for the redress that we're seeking. He also provides a charge-off statement from a Home Depot credit card ending in 1287. The account was closed off on July 29th of 2021 for non-payment. Notice of this hearing was provided to the defendant via regular and certified mail and sent on May 20th of this year. We also have for the court's consideration a certificate of last known address for the defendant and related SACRA information, including the non-active duty military status affidavit. There's also an affidavit from Mr. Todd Hines that is in the packet for the motion for default judgment that attests to the $730.41 for the reasonable and necessary attorney's fees that we're asking. That's it, Your Honor.
All right, court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff all relief requested here in open court or in its petition. Court will await a default judgment for signature. Is that the only thing you have, Mr. Gutierrez?
That's all I had, Your Honor, but I do have a quick question. In terms
Sure.
of the proposed judgment, does the court like it to be e-filed or just emailed to the clerk?
E-file.
E-filed.
E-filed, understood.
Yes, sir.
That's all I had.
All right, thank you very much, sir. You have a great day and you're excused. Okay.
You as well, Your Honor.
Yes, sir. Bye-bye. Okay. Give me somebody else.
I don't know who else is on this case.
Which case you're talking about?
Number 6.
Number 6. Number 6, I have here Mr. Turbyfield.
Yes, Your Honor. I'm here for
Yes, sir.
plaintiff.
Yes, sir. Good morning.
Good morning.
Are we expecting anybody else in this case?
Your Honor, an attorney has made an appearance for another party, but we're not seeking any relief against that party. The defendant we're seeking relief against is in default, so I don't expect anyone else, Your Honor.
Oh, okay. And who is that party?
The party we're seeking default against is defendant Warrior Noodles, LLC, doing business as Dragon Warrior Noodles.
All right. I got it right here. Okay, so the court will take judicial notice of the entire file in CO 220374D in the case of Easy Eyes LLC versus Warrior Noodles LLC, DBA Dragon Warrior Noodles. And court will note that nobody by that name is in the waiting room nor at the courthouse. And so therefore court takes judicial notice of the entire file and you may proceed, sir.
Thank you, Your Honor. Again, Lee Turbyfield here on behalf of plaintiff Easy Ice. Your Honor, this morning we're here on plaintiff's motion for entry of partial interlocutory default judgment as to the defendant Warrior Noodles. This defendant was served on February 21st. The citation and return has been filed with the clerk for the time required by law. No answer has been filed or response from the defendant. Accordingly, Your Honor, we are moving for entry of a partial interlocutory default judgment as to liability against this party. Your Honor, we have submitted a proposed judgment. We're asking for damages under the lease agreement in the amount against this defendant in the amount of $11,900.99. We're also asking for pre-judgment interest and post-judgment interest in accordance with a final judgment to be entered at a later date. We're also asking for an award of attorney's fees in an amount to be determined at a later date as well.
All right, very well. Court will hereby grant partial interlocutory default judgment in favor of Easy Eyes LLC. And court will grant plaintiff all relief requested here in open court or in its petition. Court will await a judgment for signature. Anything else, Mr. Turbyfield?
No, Your Honor, I have nothing else on the docket, if I may be excused.
You're excused. Have a great day, sir.
Thank you. You too, sir.
You too. Bye-bye. Okay. Judgment to be submitted. All right, let's
Number
see.
2.
Number Number two, let's see here. We have Mr. Okay, we're here on 41. Here it is, CL 204107D, Renwriter LLC, DBA Sylvan Learning versus RGV Insurance Agency et al. Yes, sir, Mr. Buge?
That's right, Your Honor.
Yes, sir. Good morning, sir.
Good morning.
Who do you represent, sir?
I'm here on behalf of RGV Insurance Agency.
RGV Insurance, there you go. LLC, DBA Shepherd Insurance.
That's right, Your Honor.
Okay. And it's a motion to withdraw? Oh, wait a minute. I have an order of non-suit.
Right. Plaintiff's counsel filed a motion to withdraw a couple months ago and then recently followed it up with a notice of non-suit and an order that I'm not sure if it's been executed or not, Your Honor.
I have it here signed on 6/13/2022.
Okay. Well, in my estimation, that renders the other issues moot and we're all set.
That'll do it. Thank you very much, sir, for appearing and your excuse, and have a great day. Okay, sir?
All right. Thank you, Your Honor.
You too. Bye. What else?
Carol Clark with
Mr. Clark? Let's see here.
Good morning, Your Honor.
Yes, ma'am. Yes, Ms. Clark.
Hi, I'm here on a case with Rafael de la Garza, I believe. I'm just entering this case
Okay.
in place of another lawyer, and the name of the case is Emma Quesada versus United Property and Casualty. It was set at 10 a.m.
Okay.
And it's just a scheduling conference, I believe.
Okay. And is Mr. Mr. Rafael, there's Mr. De La Garza and Mr. Ortegon. Good morning. All right. And Mr. Ortegon, can you hear me? You need to unmute, sir. There you are.
I can hear you, Your Honor.
Oh, okay. So we have, let's see, we have here Ms. Clark, Mr. Ortegon, and Mr. De La Garza. And I believe it's on the Emma Quesada case versus United Property Insurance.
That's correct.
All right. And what do we have here?
Well, for the record, Judge, I'm actually the appointed umpire on this case. However, because I happen to also be an attorney, it showed up on my docket, so I am present. I was able to read some motions, Judge, and my purpose of being here is just to dispute some of the allegations made against myself, and I guess also Mr. Salinas in that motion, Judge. I don't know if it's even my role to be able to do that, but I do have a list of emails and some things I would like to put on the record, Judge.
Okay. You're the umpire for this case?
That is correct, Your Honor. I was appointed by this honorable court.
Okay. And let me see here. So let's see, Mr. De La Garza represents, is Emma Quesada the plaintiff?
Yes, Your Honor. Rafael De La Garza from Emma Quesada for the record. I also asked my appraiser, Mr. Oscar Salinas, to be here, Your Honor. I know that all we're set for today is just a status hearing, Judge, and I believe we were also set for default. That no longer applies, just a status hearing. But I know there was also, before today's hearing, there was a notice of objection to the umpire award that was rendered by Mr. Ortegon in this case. And so, I don't know if the court wants to take up the issues that were addressed to that objection now, or if the court wants to push this off to a later date. I asked Mr. Salinas to be here because there's a lot of allegations in that motion that we feel are unsubstantiated and honestly disingenuous.
Okay. So yes.
Well, if I may, Judge, I was just going to say, I've released my award. As far as I was concerned, I released my award and I thought that this case was done. I know I am pending payment from one side, but, in reality, Judge, all I feel like I'm just here to do is address emails and, opportunities we made to the Mr. Nordemeyer as well as Mr. Salinas, just to kind of put that on the record, Your Honor, and then I can probably be excused while the rest of this hearing goes on, Judge, if I'm able to do that.
Okay. Yes. Before you do that, Ms. Clark, anything you want to say?
Well, we did file a notice of objections to the appraisal award yesterday, stating the defendant's position and why they're going to dispute the award of the umpire. So if you want to address it today, since these gentlemen are here. However, I don't have my appraiser here just because of the setting was just for a status hearing. So I don't know, it might be better to reset it, but it's up to you. You know, I can go either way.
Mr. Salinas, I just asked Mr. Salinas to be here just so I wouldn't have to repeat everything, Judge, but he doesn't have to be put on the record or anything like that. We're ready to proceed. I think the short the one is an officer of the court and was appointed as an umpire. We're ready to proceed today if it's okay with Your Honor.
Okay. Well, then, Mr. Ortegon, go ahead, sir.
Okay, Your Honor, just in reading the motion, it had stated that I did not visit the property. It stated that I was not in contact or responsive to Mr. Nordemeyer. And I'm just going to address what is alleged against me in that motion, Judge. I don't know what communications Mr. Salinas and Mr. Nordemeyer had separately, Judge, but on October 13th, 2021, I did read an email or did receive an email from Oscar Salinas directed to myself as well as Mr. Nordemeyer basically requesting when we could review the property. This is October 13th of 2021, Judge. At that point, I responded a couple minutes later, and I said that would work with me in the afternoon. However, Mr. Nordemeyer, please give me dates that you would be available over the next 2 weeks. And if both parties could send me your estimates, that would be greatly appreciated. Again, Judge, this is on October 13th, 2021. Let me see here. I believe on October 13th, 2021, Mr. Nordemeyer, he responded that the appraisal would be stalled and placed in abatement, and that he had not inspected the property as that we were waiting an umpire selection up until this point. I have followed up with the carrier's attorney this afternoon, and then there's apparently an email thread that went on. And then on January, so nothing happened, Judge. We did not visit the property at that point. On January 13th, he tagged an email thread, and then I responded on February 17th, basically saying that, what is this an abatement? Asking these gentlemen what's going on. Is this an abatement? Is it not an abatement? At which point, Judge, and I do have a couple emails. I'm just kind of going through these. On January 6th, Oscar Salinas basically said, so this is already 2.5 months later, that he has attached his estimate on the appraiser for both the appraiser and the umpire to review. Please let me know when we're available to meet the premises. This is on January 6th, Judge. On January 6th, so there's already been 2.5 months that we have not visited the premises because I'm waiting for both umpires to give me their estimates and to give me the opportunity to figure out exactly what it is that they want to do. So essentially, you can almost say that the case was stalled so that they can figure out whatever was going on. On January 6th, thank you, Justin. Will you please provide your estimate at your earliest convenience? Also, I need both sides to provide me dates in early to mid-February for inspection of the property. This was on January 6, 2022, Your Honor, which would give both parties 45 days to make arrangements to visit the property with me. On January 13th, Judge, we get an email from Mr. Nordemeyer basically apologizing for his delay, that he had COVID, that there would be an agreed appraisal would be stalled and it would be an abatement, and the email kind of goes on from there. A little notice, kind of conversations between Mr. Nordemeyer and Mr. Salinas is the way I'm reading that here. And then they do attach an email thread. At that point, Your Honor, he attaches something that is from an attorney by the name of Stephanie Guerrero to, I believe, Mr. Rafael de la Garza. This is on February 17th, where they're talking about communications, Judge. Oscar then messages me on January 25th, 2022. So we're into the new year. Have we agreed on a date to inspect this property? To which on February 22nd, 2022, I said, gentlemen, please provide me dates to visit this property over the next 2 weeks. No response from anybody on February 28th, 2022. I told everybody, Judge, I will be visiting the property on March 11th, 2022 at 1 p.m. Please make arrangements to attend on this date. And of course, at that point, Mr. Nordemeyer was stating that he could not move forward, that he appreciates my initiative to move forward with the appraisal, but that he believes it's jumping the gun of the appraisal process. Both appraisers are not in an impasse. And then on March 9th, Judge, that's the same day, Mr. Salinas responds that there essentially, I'm not going to read this whole email, but that there is an impasse and that there is an umpire selected. And that's on March 9th, Judge. At that point, Your Honor, I can't stall what I'm doing. So I go visit the property on March 11th, which is another allegation that I did not visit the property. I visit the property on March 11th, 2022, as I directed both parties with ample notice that I will be there. And then, of course, that brings me to April 12th, 2022, where I requested status on payment because I believe I hadn't received payment from Miss Clark's side up until this point, Judge. So I just wanted to briefly indicate that I did make several communications with both parties in email thread. I did ask with ample time from both parties to get me their estimates, and I did visit that property on March 11th, 2022, Judge, which was October, November, December, January, February, March, 5 months after I was appointed, which would have given both parties ample time to give me their appraisals and to meet me at the premises and, to help me do what I was appointed to do by this honorable court more efficiently, Your Honor. I just wanted to get that put on the record because, of course, there is some allegations in there that I did not visit the property, that I ignored Mr. Nordemeyer's calls and requests. None of that, which is true, Judge.
Okay, did you ever get the appraisals?
Just from Mr. Salinas. At this point, Your Honor, the only appraisal I received was from Mr. Salinas.
Salinas appraisal only, but not Nordmeyer?
Not Nordemeyer, Your Honor. Not as far as I'm seeing here in any of my emails, Judge.
All right, Ms. Clark.
Okay. First, I'd like to ask if Mr. Oregon, if I could get a copy of the emails that you referred to, just sometime soon, because I don't know if you were on at the time I explained to the judge, but I'm stepping in for Stephanie Guerrero. So the case is pretty new to me. Well, actually brand new as of yesterday. And so it would be helpful to me to be able to go back to my client and say, what about this? What about this? So,
and I'm sure Mr. Nordemeyer will have them as well as Mr. Salinas. As far as I'm concerned, I can't contact the attorneys individually, but if you'd like, I can, I can print out everything and send it to Mr. Salinas and Mr. Nordemeyer, and they can both, send them to the respective attorneys. I don't know what each party wants us to do in that situation.
That's fine with us. I can forward them to you, Ms. Clark. That's not a problem.
Okay.
So you're saying you can't communicate with the attorneys?
As far as I'm concerned, when you're an umpire, I'm only allowed to speak to the adjusters in this case, not any of the attorneys regarding this case.
Okay.
Or regarding the.
So then you wouldn't be able to send them to Mr. De La Garza either.
No, he can send them to my appraiser, Mr. Salinas, and I will happily forward them to you, Ms. Clark.
And I can also CC Mr. Nordemeyer, your appraiser, so that both of them have a copy, and they can both, I guess, however it is you want to receive them.
Sure. Okay. All right. That'll be fine.
So, Ms. Clark, when did you come into the case?
Yesterday, and I haven't even filed an appearance yet, Judge, but it'll be done today. So
Okay.
Stephanie Guerrero was no longer with the firm, so I'm stepping in place of Stephanie.
And you said yesterday?
Yesterday, yes.
Yesterday. That would be, what is it? The June
That would be the 14th.
14th. Okay, 2020. Good. So the bottom line, I think what Mr. Ortegon said is that since October 13, 2021, you've been wanting to visit the property or make arrangements to visit the property, and you couldn't get any straight answers. So you actually went on your own then on March 11th?
Mr. Salinas was present, Your Honor. I
Salinas was present. Okay.
On March 11th, Your Honor, 2022. Yes. But what I was, I guess, was that I gave both sides 5 months to get me the information I needed and to make arrangements to visit the premises with me, Judge.
Right. And so what happened? Did you complete your work? Did you come up with a number? Did you do an award? What was it?
Absolutely, Your Honor. I believe I released my award. I don't have that exact date on me, Judge, but I do know that I released my award probably about 2 to 3 weeks after, because on April 10th, I was checking the status on my payment from the defense side. So I would assume that I would have already released my award at that point, Judge.
Okay. All right. So you only got paid only from one side.
That is correct, Your Honor.
What was that payment amount?
I charged each side $1,500 equally, Your Honor.
Okay, $1,500. You got paid one time, $1,500.
So,
And
yes,
for the record, Judge, for the record,
sorry?
the umpire award is, I'm sorry, for the record, the umpire award is dated April 22nd, 2022, Judge.
And what is
April
the
20
amount?
Signed by Mr. Ortegon.
So April 22nd was the award.
Right.
And what was
Okay.
the amount of the award?
The total award here, the total award replacement cost value was $139,496.92. And then it's got a breakdown. And then the total award actual cash value after depreciation is $124,460.59. And I'll send that to you, Ms. Clark. I have your email.
Thank you. I appreciate that.
124,460.59 is the net award. Is that what it is?
That's, yes, Your Honor. That's the that's after depreciation. That's the actual cash value award.
Actual cash value. Okay.
And
Okay.
Your Honor, if I may,
Yes. Yeah.
can I kind of give you the defendant side of the story?
Yes. Yes. Uh-huh.
Okay, so from what I understand, the insured plaintiff had damage to her outer structures, to hay barns or something like that. And so that was under what they call coverage B. And her policy limit was only like $5,340. The damage to these two structures was much greater than that. And so anyway, her son called on her behalf and spoke with the carrier and explained that, this is the amount of your coverage. So that's something you need to take up with your agent, because it just is what it is. And so there was never a claim made under coverage A, which is the part that would cover the actual dwelling, the house and its contents. And so at that point, let's see, there was never anything about the contents. And then on December 14th of 2020, actually before that, in September of 2020, right after this, adjuster spoke with the son and told him, this is all the coverage there is for these outbuildings. He didn't even know that there was anything being claimed for the dwelling. So then Mr. De La Garza got involved the following month. And eventually that was in September. And then I guess in October asked that the payment be mailed to him, and then said he would be submitting documentation regarding the contents claim, because under the policy language, the insured policyholder is required to, of course, notify the carrier that they're making a claim, and then also to fill out a document called a proof of loss, saying, this is what we're claiming was lost, and so so that never happened. And it looks like in December of 2020, a demand for an appraisal was made by the plaintiff. And so the carrier still doesn't have any of that prior documentation, like the conditions precedent to having coverage. And so, so Mr. De La Garza indicated that they were going to have an appraiser, and that would be Mr. Salinas. And the carrier's position was basically, this is premature because we haven't gotten to step one yet, where you make a proof of loss, and you tell us what you're claiming. But anyway, they went ahead and appointed an appraiser themselves, Mr. Nordemeyer. And then my understanding is the way it works is that the two appraisers, they go down and they look at the property and they come up with their estimates. And then if they are far apart or they can't agree, then that is when an umpire is appointed to be the tiebreaker and, essentially resolve the matter. So the carrier's position was that the appointment of the umpire, I believe that occurred, let's see, I'm sorry, Judge, in January, I think, of 2021. And let's see, so Mr. Nordemeyer, of course, claims that he wasn't able to get in touch with Mr. Salinas, and there was just a bunch of communication issues here. And that's unfortunate, but the carrier's position was that because Mr. Nordemeyer and Mr. Salinas were never able to inspect the property and compare estimates and so forth, that there's nothing for the appraiser to resolve until that's done. And so far the plaintiffs missed the proof of loss condition precedent. And then now we have, the appointment of an umpire prematurely, because policy states that if we fail to agree on the amount of the loss, then two appraisers will choose the umpire. And if they can't agree on an umpire, then the court can make an appointment. And so anyway, so that happened, I guess, prematurely as well, because there was they had never compared estimates, and I don't even know that they I don't know if Mr. Salinas ever had an estimate. I just as I said, I'm not real familiar with the case yet, but my understanding is that bottom line is that there was never an impasse reached between the appraisers, which would trigger the appointment of an umpire. And so the carrier indicated to me that they weren't even sure that anybody had ever, visited the property. And now we know today, of course, that Mr. Ortegon said that he did on March 11th of 22, and that Mr. Salinas was there. Apparently Mr. Nordemeyer wasn't. I'm not sure why. I have not spoken with him yet. But, as of basically, today, the defendant had no idea whether the inspection had actually occurred, by the umpire. And so, excuse me. So the carrier is indicating that they've never denied the coverage for the dwelling or contents, but when the original field adjuster went out there at the very beginning of the claim and inspected the outer structures, and indicated one was a total loss and the other one had other issues, and they paid the policy limits on that. When he was there that day, he also inspected the dwelling and its contents, and he says that the policyholder never said a word about any claim to the dwelling or the contents, that there was never anything said about that. That came up later, I believe after Mr. De La Garza got involved. So, and on top of all this, there's a lot of miscommunication and people not responding to each other and so forth. So it just got kind of a mess. But the bottom line is that the carrier's position is that what they got from Mr. Salinas ended up, they don't think he's an impartial appraiser, and he just came up with a set of totals. He didn't justify the amounts or distinguish the amounts that were being sought, and then the umpire on the appraisal failed to cooperate with the carrier because they claim he didn't respond to emails and may not have even inspected the property, and he didn't consider any evaluation by the carrier's appraiser. So so basically, I think that what the carrier wants to do is set aside the umpire's award and start over and do this right, and have the policyholder fill out a proof of loss, say what she's claiming, was damaged and what she's asking for coverage for, and then have the independent appraisers, one for each side, go there together and do it like we're supposed to do. So they come up with their figures, and then if they can't agree, and then an umpire would be appointed at that point to be the tiebreaker and go from there. But at this point, the carrier is like, that whole umpire thing was premature because Mr. Salinas and Mr. Nordemeyer never even got to, really like discuss what they came up with or, compare appraisals. So that's basically why the carriers and, disputing the umpire's award.
Okay, Mr. De La Garza.
May I respond, Judge?
Yes, sir.
The bottom line is, Judge, the carrier dropped the ball. They don't like the numbers and they want another bite at the apple, Judge. That's what's going on here. I want to let the court know Ms. Emma Quesada, Judge, is 80+ years old. She doesn't speak any English. She has a hard time getting on the phone. So to expect Ms. Quesada to meet with the initial inspector and identify each crook and crevice of the house that was damaged is a little bit difficult for her to do given her age and her status. She's sick, she's a single lady, she's widowed. And so the fact is that they were out there, they did an inspection, they are the experts. Ms. Quesada is not an expert. Subsequent to that, after I got involved, you've got Mr. Salinas and Nordenmeyer that met up. Mr. Salinas is not on the record, but I can represent to the court that his testimony would be, I spoke to him before this hearing, that when he met Mr. Nordenmeyer or spoke to him, I don't know if via text, phone, or in person, Mr. Nordenmeyer indicated that he was not going to go to the property unless there was an umpire appointed. In other words, he was creating an impasse before an impasse existed. As a result of that representation, I filed the application from an appointment of an umpire. I'm going to object to their request to vacate the umpire award, Judge. What they're requesting right now and the allegations that they're making that there was the conditions preceding were not met, those issues should have been brought up when the application for the appointment of an umpire was filed with this court. We had a hearing, Your Honor appointed an umpire, Mr. Jorge Ortega, and things went forward. The fact that their appraiser didn't pick up the phone, didn't show up at the property on the date that Mr. Ortega indicated and so is not anybody's fault but their own. The other issue is this, Judge. Before Ms. Clark, as she stated correctly, there was Stephanie Guerrero was in the file. I would call Mr. Salinas and I would ask Mr. Salinas, what's going on with this file? My lady's 80+ years old. She is, very upset with me that this is not moving forward. And initially what happened is Mr. Salinas started getting messages from Mr. Nordenmeyer that this case was in abatement. And that's not true. That was never true. Mr. Salinas, I think, represented that fact to Mr. Ortega, represented the fact to Mr. Nordenmeyer that in fact it was not in abatement. I even had an email with Ms. Guerrero telling her, hey, your appraiser says that this case is in abatement, and that's complete falsity because the case has never been placed in abatement. We're going forward. There was an appraiser that was appointed by us, a subsequent umpire appointed by the court. Then what was a little odd, Judge, after those comments about abatement, I get a phone call from the carrier, and I happened to pick up the phone that day, and the carrier starts talking to me about what's going on with the case, and they want to know what they can do to move the case forward. I think there was a drop of the ball between the carrier in this case and the law firm that's representing the carrier only because of that email. And I documented that call, Judge. I sent Ms. Guerrero an email saying, hey, this is what happened today. These people called me. I don't know why they called me. They're your client, but please advise them not to contact me anymore, as that's against the rules. The last thing I want to say, Judge, is Your Honor knows that a final umpire award is final in a case. You have to show that it was made without authority, or that the award was resulted from fraud, accident, or mistake, or that it failed to comply with a policy. I don't see anything before Your Honor as far as evidence is concerned to substantiate any of those three grounds, Judge. And for that reason, we ask Your Honor to uphold the umpire award and deny their motion to vacate the umpire award issued by Mr. Ortega. And also if they can pay Mr. Ortega because we've done our part to date, Judge. That's all I have.
Well, yes, Ms. Clark.
I'm sorry, I didn't mean to interrupt you. If I just might respond to Mr. De La Garza.
Yes.
He said the carrier dropped the ball and didn't get back to him. I think that's what he just said. But it looks like from the information I have that that he inquired of the carrier, I think on like October 8th, and then an adjuster by the name of Cedric Jenkins sent Mr. De La Garza copies of the estimate and requested additional information. And on October 13th, he replied, Mr. De La Garza replied and, just saying he asked the payment be issued to his office and that they would be submitting documentation regarding the contents claim, but that never happened to my knowledge. And so, the carrier did in fact reopen the claim after it was closed, after the coverage B was all settled, once they knew that there was going to, they were making a claim under coverage A, but, they we're asking that they get the proof of loss and, comply with the policy terms. So there was, both sides are not without fault, I would say.
Okay.
Judge, and the last thing I want to say, Judge, is as your honor knows, the law doesn't require them to have, this happened to me in a case that I've got where we were not able to be present on the day of the umpire inspection, and it got finalized, and that was it. So I just want to remind the court, the umpire, in fact, I've had umpires that simply make a decision from their office in Dallas on a AAA case or whatever that has to go through AAA, and they never visit the property. They're allowed under the law to review the photos and the estimates, which Mr. Ortega had Mr. Salinas' estimate. The fact Nordenmeyer failed to submit his estimate is on him. And so that's all I've got, Judge. Thank you for your time.
Well, what the court's going to do here is take this matter under advisement and allow each side to submit a little brief or something explaining basically what you said today. You can add anything you want. And we're here on CL 21-1303D on the Emma Quesada case versus Emma Quesada versus United Property and Casualty Insurance Company. So, and submit a brief, basically what you said today, add anything that you want, and then your proposed orders. And I'll read up again and see what I can come up with.
Okay. And for the record, or just I guess before we go, Your Honor, being that I've submitted an award, being that I did give both sides over 6 months to get me as to, am I relieved of my duties on this case? And is there any way that we can order, that I be paid so I can close this file and get this closed out?
Yeah, go ahead and submit I guess your order is going to be to get paid. So just submit that. Okay, Mr. Ortega? Submit your
I've already voiced and my W-9s to both sides, Your Honor.
I'm sorry?
I've already submitted my invoice and my W-9 to both sides, Your Honor.
Oh, okay. Yeah, but submit an order where you're seeking the payment from the carrier.
I'll go ahead and get my paralegal to do that this afternoon, Judge.
All right, and as far as the other attorneys, submit the brief and again a proposed order of this matter here regarding the award.
Thank you.
Okay.
Okay.
Thank you all very much. You all may be excused. Have a great day.
Thank you. Bye-bye.
Bye-bye.
Mr. Jorge Munoz is here for Mr. Daniel Hernandez.
Oh, okay. Number seven.
And Mr. Lee Hernandez is not in the room.
All right, Mr. Jorge Munoz. Good morning, sir.
Good morning, Judge.
Sir, we are here on the June 15, 2022 docket, and your case, I believe, is CL 0610D, Jose Angel Rios versus Lee Hernandez. And you're here for Daniel Hernandez, the attorney, right, sir?
That's correct, Judge.
And you're seeking a default judgment?
Yes, Judge. We are, Judge.
All right. Court will note that Lee Hernandez is not in the waiting room and neither at the courthouse. Otherwise, I would have been made aware of that. So therefore, court takes judicial notice of the entire file in CL 220610D, Jose Angel Rios versus Lee Hernandez. And Mr. Munoz, you may proceed.
Yes, Judge. Well, I know the court's already taken judicial notice of all documents in the file, Judge, but I would ask the court to take note that we are taking a no answer default to liability only against the defendant driver, Judge. He did not file an answer in this case. The petition and the return have been in the court's file and the citation, Judge, for more than 10 days. There's also a non-military status affidavit attached to the motion. The last known address was also attached to the motion for default. And we will follow up with an order, Judge, after the court's hearing today.
All right, very well. Court will hereby grant default judgment in favor of plaintiff as regards to liability only. And court will go ahead and grant the plaintiff orally requested hearing in open court, and court will await a default judgment for signature.
Thank you, Judge. That's all
I have. Thank you very much. Your excuse. Have a good day, sir.
Number 8.
Number 8.
Mr. Patrick Kennedy.
Mr. Patrick Kennedy, there he is.
Morning, Judge.
Yes, sir. Good morning. Good to hear from you. And in regards, Juan Jesus Benavides?
Yes, it's an occupational driver's license, Your Honor.
All right. Yeah, we have an application here for an occupational license, and we have state, Miss Kelsey Cantu. And Miss Cantu, have you had a chance to go over the application?
Yes, Judge. The state has no objection.
No objection. Very well. Court will take judicial notice of the entire file in CO 22-1964D in regards to the application of Juan Jesus Benavides. Court will hereby go ahead and grant the application for occupation license. That should do it.
Thank you, Judge.
Thank you all so
Have a-
much. You're all excused.